Thank you, Mr. Chairman. Gentlemen, I don't want to spend a lot of time on this, but I also don't want to debate how many lawyers can dance on the head of a pin. I think you understand where a lot of these questions are coming from. Mr. Geiser, would you ever advise a client to ignore a federal district court opinion?
Thank you very much, Senator Kennedy. I would advise it.
Thank me. You can thank me by answering it.
I would advise a client on how best to comply with all lawful court orders.
Is that a yes or a no?
Yes, sir.
Fellow Patriots, welcome back to Republican Forum. In today's episode, we break down a heated Senate hearing where Republican lawmakers confront legal experts on the unchecked power of administrative agencies and the Department of Justice. The spotlight is on judicial compliance, the abuse of the good cause exception, and what happens when bureaucrats try to bypass the Constitution. This is about restoring balance, law, and liberty. Watch till the end and don't forget to like, share, subscribe, and hit the notification bell to stay informed with Republican Forum.
You would advise a client not to follow a federal district court opinion?
I would advise a client to follow court orders.
Would you ever advise a client not to follow a federal court of appeals decision?
I had the privilege of clerking on 2 federal courts of appeals.
So yes or no?
Yes. I would advise them to follow the orders of courts of appeals.
How about Supreme Court opinion?
Yes, Senator, I would advise them to follow the Supreme Court's orders, as President Trump has been very clear that those orders are to be followed.
Mr. Woodward, let me ask you the same question. Would you ever advise a client not to follow a district court opinion?
No, Senator.
Would you ever advise a client not to abide by an opinion of the Federal Court of Appeals?
No, Senator. Again, it's difficult to answer in the hypothetical, but...
Would you ever advise a client not to follow an opinion by the United States Supreme Court?
No, Senator. As the President has been clear, he will follow all orders of the United States Supreme Court.
Tell me what I would need to do under the APA, the Administrative Procedures Act, if I want to change a current rule.
Well, Senator, as a senator, you would pass a law that would change the...
No. I don't want to play games here, counsel. What would one have to do? What would the head of an agency have to do to overturn a current rule or regulation?
Well, Senator, I apologize. I know that there are many ways to do that, and I don't want to play games out. I want to answer the question.
That's fair.
There are many ways in which an agency can overturn a rule.
Well, you have to give notice, right?
As a general matter, yes, Senator.
Yeah. And you have to invite input, right?
As a general matter, yes, Senator.
Okay. And sometimes you have to hold a hearing, right?
Sometimes you do, Senator.
Yeah. Are there any exceptions to that under the Administrative Procedures Act?
Under the Administrative Procedures Act, I'm not aware of any exceptions, but there are exceptions under the law.
Okay. Are you familiar with the good cause exception to the Administrative Procedures Act?
Senator, I am vaguely familiar with that exception.
Okay. Do you know what it says?
No, Senator, I do not.
I understand. Here's what I'm driving at. Are you familiar with the Supreme Court's case called Loper-Bright?
Senator, I am vaguely familiar with the Supreme Court's decision in Loper-Bright.
The overturned Chevron doctrine, right?
The Chevron deference doctrine, yes, Senator.
Okay. If there is a rule promulgated by a prior administration or even by a current administration that is in clear violation of the United States Supreme Court's pronouncement under Loper-Bright, ruling unconstitutional the Chevron doctrine, would it be possible? Strike that. Would it be prudent for the Justice Department to exercise authority under the good cause exception to the APA in the public interest and forego the rule, the notice and comment.
So, Senator, thank you. I think I now understand your question. And that is I was alluding to the non-APA process. I mean, if a rule has been promulgated that is plainly unconstitutional, it absolutely would be appropriate for the Department of Justice to look at that rule and make a determination.
But my point is, you don't have to ignore the APA to do that, do you?
I would say it depends, but I take your point.
I mean, the APA provides an exception.
Yes, Senator.
It's section 553. It's right there, big as Dallas. Am I done?
Yeah.
I thought that was maybe a mouse or something.
Senator.
Now, let's get one thing straight. This hearing was a much-needed reminder of the importance of constitutional checks and balances in our country. In this session, we had senators holding two legal advisors, Mr. Geiser and Mr. Wood, to the fire about a basic question every American deserves an answer to. Do our federal agencies follow the law or not? And guess what both these guys said they'd advise their clients to obey court rulings, even those from federal district courts, appellate courts, and of course the Supreme Court. That might sound obvious, but we've seen time and time again that some of these executive branch agencies act like they're above the law, especially when it comes to politically charged issues like climate regulations or COVID-era mandates. The senators weren't done, though. They dug into the Administrative Procedures Act, which, for those who don't know, is supposed to make government agencies transparent and accountable when they issue or change rules. But here's the kicker. There's this loophole called the good cause exception. It lets agencies skip the whole process of public comment and transparency if they claim there's an emergency. Now, if that doesn't send off alarm bells, I don't know what will. Because what counts as good cause? Who decides? And what's to stop this administration or any future one from abusing that loophole to ram through unconstitutional regulations? The senators pressed these lawyers hard about this exception, and when asked about Supreme Court decisions and precedents, especially surrounding Chevron deference, their answers were vague and noncommittal. Translation? They don't even know where the line is. And that's dangerous. We're talking about unelected bureaucrats and agencies using unclear legal loopholes to bypass the American people and rewrite the law from behind a desk. Our founders built this republic on limited government and rule of law. When an agency tries to override a Supreme Court decision or issue rules that violate the Constitution, it is the DOJ's job to act, not to stall. These hearings are exactly what we need more of: accountability, transparency, patriotism. So let me be clear, the Chevron doctrine, once used to give government agencies too much power, is on life support. And that's a good thing. Because no matter who's in the White House, we the people should have the final say. Not unelected bureaucrats, not activist lawyers, not political operatives hiding in federal offices. This is a fight for the soul of our republic. So if you care about freedom, law, and order in the future of this country, stay informed, stay engaged, and keep pushing back against federal overreach. Thanks for tuning in to Republican Forum. Don't forget to like this video, share it with every patriot you know, subscribe to the channel, and hit that bell icon so you never miss an update. Until next time, God bless you and God bless the United States of America.